Morning, Miss Martinez. How are you today?
Good morning. Fine, thank you. How are you?
I'm just fine. I saw you, so that's fine. I'm glad we got video, and it sounds like your audio is fine. So great. We should be starting in 10 minutes or so.
Great.
This hearing will be a little different because we're going to have all of our witnesses. So it's going to be more people, not just lawyers and you. But it should be relatively quick if you've seen any of the other utility cases. This should be a quick and easy one, relatively speaking.
So the subject matter experts are going to be on?
Anybody who has filed testimony should be present in order to lay a foundation to admit their testimony.
Good morning.
Good morning, Mr. Elliott. Good to see you and good to hear you.
Good to see you. Same. Mr. Hearing Examiner, did you want us to admit or submit the direct testimony?
No, I don't.
Okay.
It seems like in the stipulation, the parties agreed that it will not be admitted as.
That's right. I just wanted to make sure. Okay.
Yeah, I like to keep things as simple as possible, and I can only see where that could complicate matters.
Agree. Okay.
Thank you. Good question, though. Ms. Crane is going to be here, correct?
Yes, she is. Yeah.
All right. Hi, Ms. Leyba Tessero. How are you today?
Hey, good morning. I'm fine. How are you?
Good morning. Could you just click on your video so we see if it works?
Yes, I am.
There you are. Nice. Happy Wednesday.
Happy Wednesday.
We're still waiting for people to check in. We can discuss procedural stuff, though, without everybody present. I'm going to ask Mr. Bigatko if he's got an opinion. You know, normally the normal procedure is, of course, the applicant goes first and presents their witnesses and any opposition thereto, and then if there's rebuttal after the direct. But this is in support of a stipulation, and I've read all the testimony, and I'm not sure that's the best order to go in, or that it even matters. What do you think, John?
I mean, I don't think it matters. My inclination is to, obviously, I think JMEC as the applicant would still go first. I mean, we all have a burden of supporting the stipulation, but after that, I would think that it's either Ms. Martinez or the New Mexico Attorney General, and then staff would bring up the end. That's just my first blush at it.
Well, that's what I have. I thought we would stick to the order that's normally, which would be the applicant's witness, intervener, OAG, and then staff. But as I read these things, I was thinking, what would make the most sense to somebody who is reading these? And when I did that, I put them in a slightly different order. But the truth is, we're here really to admit these into the record and make them evidence. Once they are evidence, I'll read them before I sign a certification, and I presume the commission would, or at least OGC will. And it's up to them to stack them on their desk or on their computer screen, however they like. So let's do it the normal way, lest anyone become confused.
Okay.
Or more confused in my case.
And Mr. Hearing Examiner, while we're on procedure, I know that Miss Martinez is participated in another commission proceeding. It was probably a decade ago, but how will you want to proceed with Miss Martinez entering her testimony into the record? Usually, you have the assistance of an attorney who walks the witness through the foundational elements and then requests to move it into the record.
Well, she certainly is not your witness.
That's correct.
She certainly is not my witness because I don't have any witnesses. Let's ask Ms. Martinez if she's prepared to provide a foundation for her exhibit. Hi, Ms. Martinez, you still there?
I sure am.
You're probably familiar with the questions that are asked of a witness as their testimony is being moved for admission as evidence. Are you?
I'm really not.
Okay. Well, it's basically, you will hear it when Jemez introduces the evidence of Mr. Proctor and Mr. Hastings, and then you will be next. And if you don't testify as to the necessary information, I'll ask you a few questions just to lay the foundation, unless there's an objection from the other parties. And I doubt that there is. It's relatively simple. It's, this document you submitted, which is really nice and short and concise. Geez, the pages aren't even numbered. It's 3 pages of content, a cover. I don't call that a cover sheet. I call it the caption. And then there's an affirmation. I would ask you if this is your direct testimony. If you were asked these questions today, would the answers be the same? Are there any changes? Do you want to make any changes? And that would basically be it. And then you would move to admit your testimony in support of the unopposed stipulation. I typically don't make motions for parties. That's me wearing too many hats at the same time. So you have to move that this be admitted into evidence. I think you can handle that. Is that right, Ms. Martinez?
Yes, it is. Thank you, sir.
Great. Okay. Dr. Zadelis, how are you today?
I'm doing well, Mr. Hearing Examiner. How are you doing?
I'm pretty good.
That's wonderful. Glad to hear that.
I'm glad you are both in here and both in all visually, orally, and in spirit.
I'm looking forward to it. Thank you.
I read I think I read your resume, and it was interesting because I also have a degree. I have an MBA and a JD, and I have a degree in finance and a degree in economics.
Yes.
So it was like, oh my God, like looking in a mirror almost. It's kind of close.
I don't know if I could have cut it at law school, but I took a little bit of a different path.
I think you could have cut it just fine. Law school is different now than it was.
Okay.
When I went, it seems like a long time ago. I started in 1980.
Yes.
80. And then I had 2 kids that went to law school, and I saw their work and heard about their experience in law school, and it was vastly different than mine. And now, like another 10 or 15 years has gone by, and I suspected it's vastly different today.
Yeah, it could be. Legal profession is changing. That is true.
It really is. It really is. So I'm still kind of stalling here. And I enjoy talking with you. That's kind of a pleasure.
Thank you.
We are streaming on YouTube, but we haven't gone on the record yet. I have, let's see what time. I have 9:54. I said in another hearing, I think that was this week, that the bus doesn't leave the bus stop until the scheduled time. All righty. So I mentioned, I think the velocity of money of the money supply once, and I think I got a nod from you. You actually knew what I was talking about.
Yeah. How many times the dollar gets spent in the economy, how quickly it goes through.
Absolutely. If you're a monetarist, this is a pretty substantial concept.
Well, it seems these days. Go ahead.
when I saw the government printing those $500 checks, I was absolutely horrified about a year ago, as you might imagine. And yes, the egg has hatched, and welcome to the land of inflation.
Well, hopefully that doesn't last for too long. A little bit of inflation isn't a bad thing. Too much is.
Well,
deflation, though, that's the one thing you definitely don't want deflation.
Well, I like it to track the growth in the GDP, typically. The basically, yeah, I agree with you, of course, but only to the extent that the productivity, typically from technology for the last couple of decades, supports it. And otherwise, well, it's always interesting stuff. I tell you, there we go. There's Miss Crane. Let's check her, test her audio and video. Where is Mr. Yar? Anybody talk to him this morning? No?
I actually left him a voicemail, but
okay.
Not speak to him.
Well, he should have himself and Mr. Proctor and Mr. Hastings standing by. Is that your carpenter look, Mr. Elliott?
Yes, sir.
Good. Excellent. Most excellent. Dr. Zadelis, have you read The Armchair Economist? It's a little paperback book.
I've not. I don't believe I've read that. Who is the author?
Oh God, you're testing me. I don't remember.
Is it an older book? I read the classics. I'll say that. And is it Robert Heilbronner? His History of Economic Thought. His collection of books on that. I think those are wonderful.
This is for laypersons to the field of economics, and often when someone can drag me into economic concept discussions, I will, and a non-economist, I will suggest they read that book. And I actually read it every 5 years or so and find it, it's good. It's a really good book to recommend to people that don't understand, Keynesianism and monetarism and those really broad concepts.
Absolutely. I would recommend, if you're a little bit more advanced, which you are, Mr. Hearing Examiner, reading Hyman Minsky's Stabilizing an Unstable Economy.
Hyman Minsky's.
I believe he went to University of Chicago as well.
Well, my mentor was close friends with Milton and Rhodes. Mm-hmm. And his name was Henry Sanborn. He's now deceased, but he changed my life. Really. He wrote a book called What, When, For Whom, I believe it's name. I can see the cover. And that was our textbook in Econ 101. Of course, he literally wrote the book. And, that's when I actually changed my major from music to economics.
That is a change.
It is quite a change after the first semester. Okay, so Mr. Yar, I'm really happy to see you. How are you today?
Good, thank you, Your Honor.
Is that Mr. Hastings next to you?
It is, sir. Thank you.
Hi, Mr. Hastings. Nice to put a face to the name. I've been reading your testimony, so I feel like I know you just a little bit. Okay, we have enough people here to start this hearing. Is Mr. Proctor standing by, Mr. Yar?
He is, Your Honor.
Okay, so we had just a real brief discussion before you came on, and it was just procedural, like what were the proper order? And I made a comment that, normally, of course, we go with the applicant and then end up with staff and typically interveners in between. And my only comment, I just wanted to fill you in on what you missed, was that when I read these things, I actually read them twice. I read them when they came in, and then I read them last night sitting in my armchair. Actually, I read them a third time this morning. And it seemed to me that there was a better order, like defining some of the terminology. But I'm just fine. If we were going to be presenting live testimony, I would have suggested a different order than the normal order but because this testimony is simply to provide evidence in support of the stipulation. It would seem to be a concurrence, or no one disagreed with me, that we will present in the traditional order, which would be your witnesses, then Ms. Martinez, and then Ms. Crane, and then Ms. Leva-Tercero and Dr. Zadelis. So are you good with that as well, Mr. Yar?
I am, Your Honor.
Okay. I'm ready to go. Is everybody ready to go? Okay. Ms. Gonsalves, could we please go on the record?
Yes, you bet.
Thank you. Good morning, everyone. We are on the record. My name is Robert Lennon. I'm a hearing examiner with the New Mexico Public Regulations Commission. This is case number 21-00318UT. I'm going to read the caption. In the matter of request for approval of general rate adjustment pursuant to 17.9.540 filed by Jemez Mountains Electric Cooperative Inc. petitioner. And that's exactly what this case is about. This is a co-op rate case. And co-op rate cases for the general public, by the way, we are on YouTube, they're distinctly different than the typical investor-owned utility rate cases that some people may be familiar with. They're unique because they consist of members, not purely shareholders and ratepayers. The distinction gets just a little bit blurred. So they're a unique kind of case. And this is a unique kind of resolution of the case because the parties informed me on the eve, I think it was, the afternoon of the eve before the evidentiary hearing was to begin, that a stipulation was in order. A stipulation was achieved. The stipulation is not, it requires approval by the commission. We need a final order of the commission. And in order to get that, the stipulation has to be certified. In order that the stipulation be certified, and that's the part that I do, I actually sign the certification. I actually write the certification with help in this particular case. But the certification has to be based upon evidence. The evidence typically is sworn testimony. This hearing today is to move sworn testimony into evidence. Once it becomes evidence, then it can be considered in the stipulation, and it becomes considered by the commission, who passes the final order, hopefully, based on the evidence. So the evidence that's necessary is evidence of the criteria which the commission has set forth, and it's been in case law, actually, that the stipulation is the product of serious bargaining among capable, knowledgeable parties, typically arm's length negotiation, not one-sided, not one side pushing another side around. And this has to be acknowledged by the parties in the evidence. Two, does the stipulation as a whole benefit customers and the public interest? That's where, you know, a co-op case is slightly different because the customers own the co-op and their members, their customers. And next is, does the stipulation violate any important regulatory principle or practice? And to me, that means a balancing of the need and the intent of the entire process to achieve reliable service, reliable electricity service provided at fair and reasonable cost. And that's what this whole thing is about. That's what this case is about. And I think everyone that's on the screen right now comprehends that. But, I'm setting the stage, if you permit me, for the greater audience, because I'm sure there's people tuning in on YouTube, and they may not be as familiar with this proceeding. They might find this proceeding abbreviated and be surprised by how abbreviated it is, because I expect a relatively quick, abbreviated hearing. There can be cross-examination. it has to be adversarial cross-examination, not friendly cross-examination. That's because direct testimony at the commission is submitted in writing. So the parties are typically going to move for admission of their direct testimony. In this case, it's direct testimony in support of the unopposed stipulation. If I have any questions, I don't really have a horse in the race, so to speak. My examination is not to cross-examine a witness or to impeach the veracity of the witness or to impeach the reliability of the evidence. I'm trying really to clarify, mostly for my help, to help me, and perhaps for the commission, should they review the testimony, review the transcript, and perhaps even for the general public or anyone that's interested in the case, if there's something which was not clear to me or that I believe could be clearer. And that's why I might ask a question. Like I said, it's not to cross-examine in the traditional sense. So I have talked already too much because this hearing should proceed quickly. We had a pre-hearing conference on Monday. The pre-hearing conference was to discuss the procedure to be followed today. I think everyone was in concurrence and was agreeable. But I said that I asked if anyone wanted to make an opening statement, and I said that I would set the stage, if you will. And I believe I've done just that. But I'll ask again, if anybody wants to make an opening statement, I'll ask broadly. Raise your right hand or tell me or nod. No, I'm looking at all counsel on the screen. No one wants to make an opening statement. So we will proceed to the testimony. Mr. Yar, would you care to present your first witness?
Thank you, Your Honor. I call to the case Mr. Hastings as my first witness.
Thank you. Ms. Gonsalves, would you mind swearing in Mr. Hastings, please?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Thank you. You're a witness, sir.
Thank you, Your Honor. Mr. Hastings, can you please state your name, your full name for the record, where you work, and your role at that company?
My name is Michael Wayne Hastings. I work at Jemez Mountains Electric Cooperative, Inc. The headquarters are in Hernandez, New Mexico, and I serve as the co-op's CEO and general manager.
Thank you, Mr. Hastings. I've just slid across to you a document labeled JMEC Exhibit 1. Are you familiar with that document, sir?
Yes, sir.
Can you tell us what that document is?
Yes, this is my testimony, which is to support the unopposed stipulation filed in this case.
Mr. Hastings, was that testimony created by you or under your direct supervision?
Yes, it was.
Mr. Hastings, do you have any corrections to make to that testimony?
I do not.
Mr. Hastings, is that testimony accurate and true to the best of your knowledge?
Yes, it is.
Your Honor, with that, I'd like to move JMEC Exhibit 1 into the record.
Is there any objection? So normally I will poll, actually, but I'm going to rely upon you guys to speak up. And I watch for cues. I don't see any objection from counsel from any other parties for the record, Ms. Gonsalves. Let's see if I have any questions. And like I said, mine is not cross-examination. Sir, what exactly do you do at Jemez, or Jemez, as I say?
I basically am the manager of the co-op, just responsible for the day-to-day operations, whether it be the accounting or billing or IT or engineering or the work that the linemen do, meter reads, just soup to nuts.
Would it be fair to say that you're the boss?
Yes, sir.
Thank you. There has been a compromise in the amount of the requested base rate and it's a substantial compromise from about 11% down to about 9. I'm just very roughly stating that 9.33, if my memory is correct. Is that correct?
Yes, we've gone from our initial request of 11.65% overall increase to the settlement amount, which is a 9.33% overall increase.
Would you consider that a substantial compromise?
Yes, I would. We will be going back to the drawing board, so to speak, as we prepare our 2023 budget, which we're working on right now. But we're going to have to be really careful here. As far as the things that we were hoping that we could do, we're going to have to kind of pull back a little bit, maybe stretch some projects out over a few years, that sort of thing. Maybe not have as many employees as that we'd hope to have, but just be very careful, with our members' money.
Thank you for answering my next question, which was how are you going to do that? And you've already answered it. And I did see, I saw Mr. Proctor's testimony regarding that. So I just wanted to get it in while you were on the witness stand and you were under oath. You mentioned on page 8, line 18, you don't have to pull it up, but basically that the stipulation balances the interest of Jemez in securing financial stability. What do you mean by that?
It's really important that the electric cooperative has enough money to operate.
Right.
But on the other hand, it's all the members have to pay for that. And so to the degree that we're increasing their rates, obviously, what we do has to be balanced against that. And I think that what we've done here is a fair balance between the interests of the co-op to try to maintain and do what we need to the system to improve it, coupled with the issues associated with our members and their needs to have the lowest rates possible from our perspective.
And the rate's going to be imposed as soon as the commission orders the final order. So that actually is a feather in your cap rather than having to phase it in over time. Isn't that correct?
Yes. I don't know for sure if I'd call it a feather in my cap or our cap. For us, phasing it in over 2 years just wouldn't have worked with our lenders. That was the issue with that.
Okay. Arm's length negotiation. Was it in fact at arm's length?
Yes, I think it was. I think there was a lot of good discussion between our counsel, Mr. Yar, as well as counsel for the PRC staff, as well as the AG, and also with Mrs. Martinez. In other words, there was a lot of discussion and there was give and take.
Well, thanks for bringing up Ms. Martinez. Again, you anticipated my next question, which was, she is basically pursuing transparency. It's one of her pursuits at least. And you've agreed to submit to the board some new proposed bylaws. Am I understanding that correctly?
Yes, sir, that's exactly right. And what we did this year was, for the first time in 29 years, we've been able to amend our bylaws. We hadn't had a legal annual meeting, or what I would describe as a legal annual meeting, in 29 years. And the reason for that was because we couldn't get a quorum. Our quorum requirement was 5% of the members, which is over 12,000 folks. And despite our best efforts in 2021, we weren't able to do that. And so we pursued another avenue to amend our bylaws. And this summer, we were able to lower that quorum requirement to 2.5%. Now that we've done that, my strong preference, and I've talked to the board about this a number of times, is that we need to be taking bylaws to the members every year for a while. I don't know exactly how many years, because it'll depend on how many bylaws we present each year. The challenge there, sir, is the is the balance between needing to get these bylaw amendments done as quickly as we can to fix the worst set of bylaws I've ever seen in my career, coupled with the fact that once you get past 3 or 4 bylaw amendments, the members' eyes start glazing over because it's just too much. It's just too much, and so that'll be the deal there. But what we're going to do is we're going to have a committee of the whole, and all 11 of our board members. It'll be chaired by our board president, and then we're going to try to get one member from each of the 6 districts that we have, and those will be non-voting members. But what we plan to do is advertise or put a notice out for interested members in the paper, on our website, et cetera, asking them if they're interested to put their name in the hat. And then those 6 will be chosen, and then we'll get to work here, hopefully early in January 2023 on bylaw amendments to take to the members next summer. I'm sorry, Mr. Gordy.
No, it's actually perfect. And you know what I was concerned about is that you, as the boss, and subject to a board, that you might have written. I'm going to use another analog, but you might have written a check in the negotiating to arrive at the stipulation that you could not thereafter cash, and that was you might have agreed to it, but there's the board, and there's going to probably be another board. And can they, in fact, provide what Ms. Martinez was looking for, which is what you just described? But in addition, the publishing on the website of the plan, and also, interestingly, of the credit card receipts. So do you think you can actually accomplish that?
Yes, sir, I do. Most all of the things that Mrs. Martinez requested are things that I would hand to any member that came in through the door and requested. In other words, they're legitimate, realistic things that our members may want to know. Now, there's some personal information in some cases that we have to redact, but other than that, it's their information. It's the co-op's information, and they're entitled to it as owners.
Well, of course, you mentioned the door. They don't walk in the door every day, but more of them might log on to the website every week or month or 6 months or the year than be inclined to literally walk in the door and ask you to hand them something. Maybe you were saying that you were also using analogy, but so you definitely can do. You can. Ms. Martinez can cash that check. This stuff will be on the website, correct?
Yes, sir. That is part of our agreement to this settlement, to this stipulation. Yes, sir.
All right. Actually, I don't have any other questions for you, but since I asked a few, I'm going to ask council if they have any follow-up within the scope of my questions. Let's start with, Mr. Yar, but remember, it should be within the scope and within the scope of my interrogation, please.
Sure, Your Honor. I just have a couple of really quick clarification questions. Mr. Hastings, when you were answering the question from the hearing examiner regarding the credit card statements and vouchers and whether or not you could could cash that check, so to speak, can you tell us if the board has already approved the posting of the credit card statements and vouchers?
I believe they have. I need to be careful. I'm not 100% sure, but I'm about 99% sure. And I can go back and check this, but I think we discussed this at our last board meeting. I just, I don't want to say that. I don't want to say something that's not true. Okay. So, but no, I don't think there's going to be any problems with these requests because, like I said, there are things that our members are entitled to anyway.
Okay, thank you for that clarification. And just to be completely clear on the record, the bylaws, when the hearing examiner was talking about the bylaws, again, whether or not you could cash that check, the bylaws that were part of the settlement agreement were proposals and they would be considered. Can you tell us a little bit more about the procedure that you were talking about with the hearing examiner relative to how the committee of the whole was established and how bylaws would be considered?
Yes, that idea about the bylaws and how we were going to approach it developed over a series of months or a period of months as we discuss this at the board level. I'm obviously very interested in bylaws and have a lot of experience with them. But at the end of the day, even though I'll be glad to share my expertise or my knowledge about this stuff, it's the board that's going to have to make the decisions on what we take to the members. It's not my decision. And then we wanted to get some other ideas as well from other members that might be interested. And we do have some. And in that regards, specifically, what our plan is to honor our agreement in the stipulation by taking Mrs. Martinez's suggested bylaw amendments to that committee. And that committee then will review those and give them due consideration, as well as some other bylaws, some proposed bylaw amendments that we've received from our general counsel, Frank Koppler, from a group of members a few years ago, led in part by Mr. David Neal in District 6. And I think there's also another set of bylaws that it'll be part of the mix as we consider things and decide what to take to the members in 2023.
Thank you, Mr. Hastings. Nothing further, Your Honor.
And thank you, Mr. Yar. Let's see if there's any other questions. Mr. Bogotko, any?
No questions for Mr. Hastings, but we thank him for his participation and his testimony today.
In no particular order, Ms. Martinez, any questions within the scope of the questions I ask?
No. I just want to clarify.
You're not testifying, so this is where you ask him questions.
Okay, so when I asked, Mr. Hastings, when I asked for the credit card statements and the vouchers during discovery, you didn't provide it, but today you tell us that, it's normally, if these requests are made to the co-op, you provide them to us. Can you tell me why you didn't provide it to me during the discovery?
I don't think that's sustained. Okay, so Ms. Martinez, I don't think that's actually relevant to the issues at this proceeding today, which is to receive testimony in support of the stipulation. So next question, if any.
I don't have any, Your Honor. Thank you.
Thank you. Mr. Elliott, any question?
None. Thank you.
I didn't hear who made that objection. Maybe Ms. Gonsalves also didn't hear it. Who was that?
Sorry, Your Honor. This was Joseph Yar on behalf of JMEC. We objected to that question.
Okay, thank you. All right, so are you ready to present Mr. Your next witness, sir?
Yes, Your Honor. We're just going to do a seat change here real quick.
Thank you.
Your Honor,
Yes,
I would like to call to the stand Mr. Justin Proctor.
Proctor, correct, Mr. Proctor?
Yes, sir.
Hi, welcome, and thank you for being here. Prepare to be sworn. Ms. Gonsalves, please.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Proceed, Counselor.
Thank you, Your Honor. Mr. Proctor, can you please state your full name for the record, the company you work for, and what relationship you have in this case to that?
My name is Justin Will Proctor. I work at C.H. Guernsey and Company in Oklahoma City, and I'm a managing consultant there and provided cost of service and rate support for Jemez Mountains.
Thank you. Mr. Proctor, I'm sliding across to a document marked JMEC Exhibit Number 2. Are you familiar with that document?
Yes, this is my testimony in support of the unopposed stipulation.
Thank you. Is this testimony the testimony that you prepared or was under your prepared under your direct supervision?
Yes.
Are there any changes to this testimony?
No.
Is this testimony true and accurate to the best of your knowledge?
Yes.
Your Honor, with that, I would like to go ahead and move JMEC Exhibit Number 2 into the record, Your Honor.
Let's see if there's any objection. Mr. Bagato.
No objection, Mr. Hearing Examiner. Thank you.
Mr. Elliott.
No objection. Thank you.
Ms. Martinez.
No objection, Your Honor.
There being no objection, HEMIC number 2 is admitted into the record. And I don't actually remember, but if I didn't state it as clear as possible, HEMIC number 1 is also admitted as evidence. All right, let's see if there's any, like I said, there should not be cross-examination, but let's see, Mr. Bagato, any questions for this witness?
No cross for Mr. Proctor, but we thank him for his testimony and participation today.
Mr. Elliott?
No questions, and we also thank him for being here today.
Ms. Martinez?
No cross, Your Honor.
Thank you. And as I mentioned, I don't cross-examine witnesses. I just clarify something which I think may be helpful. So let me see, bear with me just a moment to review my notes. Before I forget, Mr. Proctor, it sounded like you said opposed stipulation when you identified the document. Did you actually say unopposed, or did you mean unopposed?
Unopposed, yes, sir.
Thank you. All right, I do have a few questions.
Okay.
About the what's known as debt coverage ratios. So you use the term DSC, but it's not really defined. What does that mean?
The modified debt service coverage ratio is a metric that that the cooperative's lender CFC requires that they meet in order to prove that the cooperative is financially sound.
Because they lend money to the co-op, correct?
Yes, sir.
And what is that minimum requirement?
It's a 1.35, sir.
And then there's not the modified. Well, tell me the difference between the modified and the not modified.
Okay, so the DSC, if we were to look at the stipulation or the exhibit.
It's on page 4 of your testimony.
Okay, so the DSC is taking into consideration the net margins of the cooperative, whereas the modified DSC does not take in all of the items within the non-operating margins, if you will.
Okay. So mandated by the Rural Utilities Cooperative Financing Corporation is a figure of 1.35 for the MDSC. That's your testimony.
Yes.
Yeah. So I don't know if you even know the answer, but how do they arrive at that number?
I don't know how they arrived at that number many, many years ago. It's been that way for quite a long time.
Well, that would be typically, when you lend money to someone, you want to secure the debt with something you can sell for more than the money you lent them. Am I correct about that?
I would suspect so.
Well, that would be greater than 1 as a quantification of the security, right?
Yes.
So the 0.35, which is greater than 1, would be some sort of buffer?
I guess you could characterize that, yes.
Would that be based on the nature of the business to whom the money is being lent?
Again, I don't know how they got to that metric, sir. It predates me.
But it's kind of important here, right?
It is very important, yes, sir.
So for metrics like this, often there are industry standards or at least industry ranges which are available. Are you familiar with that kind of thing?
Well, CFC requires that they meet the minimum. It's an average of 2 of the previous 3 years. They don't provide a range, though.
Well, as I was reading your testimony, I was thinking, what do the other guys do? The other co-ops. And, I noticed that you're in the business of, you actually stated on page 1, I primarily prepare cost of service and rate studies for rural electric cooperatives. So I'm really interested in the ones in New Mexico. And I'm wondering, is there a range of what the other, not what the financing corporation requires, but is there a range of the actual ratio for the other cooperatives?
So generally speaking, a cooperative will monitor these ratios. The cooperative staff will report what the ratio is on a monthly basis. And the idea is, as long as the cooperative is meeting all of its coverage ratios and is meeting its financial goals and objectives, then there may not be any need for additional rate revenue. As the coverage ratios deteriorate, whichever one of them, the cooperative might be at risk of not meeting, then they start looking at the need for additional rate revenue or the process of going through a cost of service and rate study. A board of directors may suggest that if we ever get down to, for instance, a 1.45, that is a trigger for us to begin this process. And they may do that for the other coverage ratios as well.
So basically, the line, it's a line, if you will, is to allow liquidity. Am I correct in understanding that?
If the cooperative is not meeting its coverage ratios, yes, there could be, repercussions, in terms of access to capital.
Well, can they go shopping around to borrow from somebody else?
Generally speaking, there's 3 primary lenders in the electric cooperative industry. It's CFC, which is a cooperative in and of itself. Mm-hmm. There's rural utility services. And then there's another lender called CoBank.
And then there's the rural utilities cooperative finance, of course.
Rural utility services, yes, sir.
I'm sorry, please repeat your answer.
The RUS is the rural utility services. And that is a part of the USDA.
Okay. Hold on just a second. Let me see if I have any other notes. Actually, no, I don't have any further questions. I appreciate you, Mr. Tolberg. And if you're in New Mexico, welcome to New Mexico from Oklahoma City.
Thank you.
Let's see, any questionings, this is not cross-examination. You already had that. This was just my questions to clarify. If you have something within the scope of the questions I just asked, especially if it wasn't clear, his answer or my question. No particular order. Let's go to Ms. Martinez.
No, Your Honor, I don't have any questions to ask him.
Thank you. Mr. Elliott?
No, thank you.
That leaves not but least Mr. Bogatka.
No, thank you, Mr. Hearing Examiner.
All right. Mr. Yar, can this witness be released?
Your Honor, I just have a quick question.
Sure. I'm sorry. I didn't mean to avoid you. Go ahead.
It's okay. There's a lot of people on this thing. Mr. Proctor, again, can you just piggybacking off of the hearing examiner's questions regarding the tier requirements? You mentioned that there's a federal agency that lends money, and that was RUS, correct?
The RUS, yes.
And that's called the Rural Utility Services?
Yes.
And that's part of the USDA?
Yes.
And those tier requirements are governed by CFRs for RUS?
The O tier, tier, and DSC, yes.
Okay, nothing further, Your Honor.
Code of Federal Regulations, sir?
Yes.
Thank you. And I have no further questions. So let's, may we allow this witness to be released, Mr. Yar?
Please, Your Honor.
All right, sir. Thank you again for being here. Enjoyed talking with you.
Thank you.
All right. So next we'll move on to Ms. Martinez. Is that okay, Ms. Martinez? Are you ready?
Yes.
All right. I have your testimony in support of the unopposed stipulation in my hand dated November 4th, 2022. What would you like to do with it?
I'd like to move to file it as evidence to the unopposed stipulation today.
You'd like it to be admitted as evidence, right?
That's correct, sir.
Okay. It consists of, it's hard to ask yourself questions, but actually I've seen people do it. Actually, it is a procedure that can be followed, but I'll just ask you a few questions just to, unless any of the other lawyers object. And it looks like your testimony consists of the caption, which is the first page, then 1, 2, 3 pages of testimony, and then an affirmation and a certificate of service. Is that correct?
That's correct, sir.
And it's in the form of questions which are asked of you, correct?
That's correct.
So if you were asked these questions today, would your answers be the same?
Yes, sir, they would be.
Do they remain true and accurate?
Yes, they do, sir.
Okay. Since you've made the motion, is there any objection to admission of testimony in support of unopposed stipulation of Loida Martinez? Okay.
No objection, Mr. Hearing Examiner. Thank you.
None from staff?
I'm sorry, Mr. Bogotko, I'm sorry.
No objection from staff. Thank you.
Mr. Yar?
No objection, Your Honor.
Mr. Elliott?
No objection.
All right, I think we got everybody, and there's no objection. When there's no objection, there's really nothing for me to decide. Ms. Martinez, did you send one in with a label on it?
Yes, I did, sir.
And how
you mean physically?
Well, no, I mean, did you send it by email to the court reporter with
Yes, I did, sir.
And how did you label it?
As Exhibit 1.
Exhibit?
And then
Go ahead.
And I identified it as Intervenors Exhibit 1. Then I put the PRC case number on it, 21-00318-UT.
Okay.
And then I said Loida Martinez unopposed stipulation testimony.
In support of the unopposed stipulation.
That's correct, sir.
Thank you, Ms. Martinez. And that exhibit is hereby admitted into evidence. Let's move on. Excuse me. I have a little, I guess they call it a frog in my throat. Mr. Gonzalez, you can include that or not. I don't think it's important either way. Office of General Counsel, Attorney General, are you ready to present Ms. Crane?
I am. I believe she's in the waiting room, correct?
I didn't require a waiting room, actually.
Okay.
So Ms. Crane, good to see you. Glad you're here.
Yeah, I'm here. Thank you. Good morning.
Mr. Elliott, your witness.
Thank you. Morning, Ms. Crane. Can you please state your name and employment for the record?
Oh, wait.
Do I need to be sworn?
Yes, you do.
Yes, please. Thank you. Pardon me.
Okay, pardon me too. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Now you can proceed, and with my apologies.
Good morning, Ms. Crane. Would you please state your name and employment for the record?
Yes, my name is Andrea C. Crane. I'm the president of the Columbia Group, and for this engagement, I've been engaged by the Office of Attorney General.
And you should have a document in front of you that's been marked NMAG Exhibit 1.
Yes.
Can you please identify that document?
This is my testimony in support of unopposed stipulation in this case.
And was that testimony prepared by you or at your direction?
Yes, I prepared it.
And do you have any corrections today?
No, I do not.
Ms. Crane, is your testimony true and correct to the best of your knowledge?
It is.
And if the same questions were asked of you in your testimony were asked of you here today, would they be the same?
Yes, they would.
Thank you. I would move for admission of NMAG Exhibit 1 into evidence.
And I might have a few questions, and I want to see if anybody else has any questions. Mr. Bogotko.
First of all, no objection to the admission of NMEG1 into evidence, and we do not have any cross-examination for Ms. Crane, but we thank her very much for her participation in this case.
Mr. Yar?
No objection to her testimony coming in and no questions, Your Honor.
Ms. Martinez?
No objections, sir.
Okay, well, I'm going to ask the questions before I admit it, before I likely admit it. Ms. Crane, thank you for being here and thank you for allowing me to ask a few questions. I'm not cross-examining you. I just wanted to ask a few questions, which I think could be helpful. Is it my correct understanding that you did not actually participate in negotiation of the stipulation? And if not, what was your role?
Yeah, in a lot of cases, I will actually sit down with representatives from the company and, physically engage in a back and forth with the individuals from all parties in order to reach a settlement in a case, or not, but in order to attempt to reach a settlement in a case. My recollection is that in this case, I did not personally do that. Rather, from the Attorney General's perspective, the negotiations were primarily conducted by counsel. However, I was advising counsel, so I was indirectly involved, but I did not literally sit down and participate actively in the negotiation with company personnel.
Were your suggestions, I'm going to characterize them as suggestions to a position, if you will, and you can correct me if I'm asking the wrong question, as offered to the Attorney General's office, were they followed by the Attorney General's office?
Yes, I believe they were, and that's pretty much why I was able to support the stipulation as I have in my testimony.
And you could not have stated it more clearly, in my opinion, but on page 14, beginning at line 10, you state, and I'm going to read it into the record. I recommend that the NMPRC find that the unopposed stipulation was aggressively negotiated, is supported by substantial evidence in the record, results in just and reasonable rates, and is in the public interest, period. Therefore, I recommend that the NMPRC approve the unopposed stipulation as filed. That is your testimony, correct?
Yes, that is my testimony.
All right, so I don't have any other questions of this witness. Are there any follow-ups within the scope of mine? Mr. Elliott?
None. Thank you very much.
Thank you. Mr. Yar?
None, Your Honor. Thank you.
Ms. Martinez?
No, sir.
Mr. Bogotko?
No follow-up within the scope of your questions. Thank you, Mr. Hearing Examiner.
Mr. Elliott, can this witness be released?
Yes.
Wonderful. See you later, Ms. Crane. Thank you.
Okay, thank you very much.
All right, let's go to staff. Let's see. We have both staff witnesses present. It's your call, Mr. Bogotko. Present your case.
Mr. Hearing Examiner, I would like to call Ms. Leyva first to the stand, please.
Okay, please be sworn in, Mr. Tessero. Ms. Gonzalez, please.
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And off the record, I'm sorry, Ms. Gonzalez, I pronounced your name incorrectly. Your witness, counselor.
Thank you. Good morning, Ms. Leyva. How are you?
Good morning. I'm doing well. How are you?
I am fine. I trust and hope that you have in front of you a copy of the testimony you filed in support of the stipulation on November 4th, 2022. Am I correct?
Yes, I do.
And it's been provisionally marked as Staff Exhibit 1. Is that what you see on your copy?
Yes.
Would you just take a moment and flip through that and make sure that it is a complete and accurate rendition of the testimony you filed in this case on November 4th, 2022?
Yes, it is.
And it's my understanding that you have no corrections to make to this pre-filed testimony. Am I correct?
That's correct.
And Ms. Labor-Tessero, if you were asked today at this public hearing the same questions that we see posed and answered in your pre-filed testimony, would your answers to those questions be the same, or would you now have changes to make to those answers?
Yes, my answers would be the same.
Well, with that, Mr. Hearing Examiner, I would move for admission into the evidentiary record Ms. Labor-Tessero's testimony in support of the unopposed stipulation that I've provisionally marked as Staff Exhibit 1.
I presume no cross-examination unless somebody says they want to cross-examine. And I hear nothing from any other counsel. And I have no questions for this witness. So there being no objection, is there any objection to admission of this evidence? None, no objection. And I have no further questions. And there being no objection, Staff Exhibit number 1, the testimony of Alicia C. Labor-Tessero is admitted into the record. And if I wasn't clear before, all the previous testimonies in support of the unopposed stipulation are also admitted. So sorry, that wasn't very exciting, Ms. Tessero, but you're released.
Thank you.
Your next witness, sir.
Thank you, Mr. Hearing Examiner. I would call my next and last witness, Dr. Bryce Zadalis, to the stand, please.
Welcome, Mr. Zadalis. Prepare to be sworn in. Ms. Gonsalves.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Bogotko.
Thank you, Mr. Hearing Examiner. Dr. Zadalis, good morning. How are you?
I'm doing well. Thank you, Mr. Bogotko.
I trust and hope you have a copy of your testimony you filed in support of the unopposed stipulation in front of you. Is that correct?
Yes, sir. I do have a copy of the testimony in support of the unopposed stipulation of Dr. Bryce E. Zadalis.
And that's dated November 4th, 2022, correct?
Yes, sir. November 4th, 2022.
And do you see down there in the right-hand lower corner of the first page, I've provisionally marked it as Staff Exhibit 2. Does that meet with what you're seeing?
Yes, it does.
Dr. Zadalis, would you just take a moment and flip through that Staff Exhibit 2 to make sure it is a complete and accurate rendition of what you caused to be filed in this case on November 4th, 2022?
I will do so right now. Yes, it does. It is a complete and full rendition of my testimony in support of the unopposed stipulation.
And Dr. Zadalis, it is my hope and belief that you do not have any corrections to make to this pre-filed testimony. Am I going to be disappointed in those hopes and beliefs, or do you have any changes to make?
There are no corrections to this testimony. Thank you.
Thank you so much for that, Dr. Zadalis. And then finally, today, this public hearing, if you were asked the questions we see posed in that pre-filed testimony, would your answers for those questions be the same as what we see in Staff Exhibit 2, or would you have cause to now change any of those answers?
I would answer the questions in the same manner in which I've answered them in my direct testimony in support of the unopposed stipulation.
Thank you so much for that, Dr. Zadalis. And with that, Mr. Hearing Examiner, I would move into the admission of the evidentiary record Dr. Zadalis's testimony in support of the unopposed stipulation, which I've provisionally marked as Staff Exhibit 2.
Counsel, any objection to the motion for admission? Okay, I have just a question before I rule on the motion to admit. Dr. Zadalis, did you actively participate in negotiation of the stipulation?
Only through our counsel, John Bogotko, advising him on what I felt as though was reasonable and is supported in the evidence.
I have no further questions because I asked one. Anybody have any follow-up? No. Okay, the motion to admit the testimony in support of the unopposed stipulation of Dr. Bryce E.A. Zizales, dated November 4th, 2022, is hereby admitted into the record and is evidence in this case, which involves the certification of a stipulation. So, do we have any other evidence to present, counselors? None.
Nothing further from staff. Thank you, Mr. Hearing Examiner.
Well, just that the record be clear, I'll ask the other parties. Mr. Yar, any other evidence?
No, Your Honor.
Mr. Elliott?
No, Your Honor.
And finally, last but not least, Ms. Martinez, is there anything else you'd like to present in support of the stipulation?
No, sir, but I have a question. I wasn't sworn in. Does that make a difference?
It does make a difference. We can repeat your testimony right now, and let's do that. I apologize. That's my mistake. I take care of that, or I ask the reporter to do that. Ms. Gonsalves, could you swear in Ms. Martinez?
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Ms. Martinez, what would you like to do?
I want to file my testimony in support of the unopposed stipulation as evidence to this case.
You're moving for admission of the document interveners number 1. Is that correct?
Interveners Exhibit 1. Yes, 1. Sir.
And I think you've identified yourself sufficiently. If you were asked these same questions in this document, would your answers be the same as in this testimony in support of the unopposed stipulation? In other words, is there any changes? Are there any changes?
No, sir, there's not.
Okay. Are the answers still, I think you have an affirmation here. Are they still true and correct on the penalties of perjury? Are they correct?
Yes, they are, sir.
All right. Any objection to the admission of the testimony in support of the unopposed stipulation of Loida Martinez? There being no objection, Ms. Martinez's testimony is admitted into evidence. And thank you very much, Ms. Martinez, and I apologize for that. And I apologize to other counsel that we had to briefly go through that again. Is there anything else or anybody else I didn't swear in? No. I didn't even get a smile from that. There's
I smiled.
Mr. Yar smiled.
I was wondering if you were going to swear me in.
I don't think Ms. Gonzalez, we're bantering just a bit, so you're a professional and you can do what you like. If you want to leave that in to keep the record complete, that's fine. But if you feel it's appropriate to strike it, that's also fine. Okay, let's, is there anything else we need to address here? I understand that you guys do not intend to do any type of closing arguments. Is that correct? Okay. And there's nods in affirmation for the record. Now, we did have a schedule for, pardon me, in the third procedural order that a proposed certification will be submitted on or before November 16th. We're still on the record here. Obviously, that will require a, well, I'll just leave it at that. Are the parties prepared to submit a proposed certification? Mr. Bagacco?
Yes, Mr. Hearing Examiner, I have it on my calendar for November 16th, and I'm prepared to collaborate with the parties on that document.
Yeah, exactly. That's the stuff that we've actually discussed in the pre-hearing conference. There's been no change. Is that correct, Mr. Elliott?
That's correct.
And no change, Mr. Yar?
That's correct, Your Honor.
And Ms. Martinez, you were there as well, right? Of course you were, on Monday.
Yes, sir.
And correct me if I'm wrong, but the agreement is that there'll be joint proposed certification. It'll be circulated among the parties. Is my memory correct, Ms. Martinez?
That's the way I understood it, sir.
Okay. All right. I don't see anybody disagreeing. And I'm ready to adjourn this hearing unless there's some reason we should not. I'm going to ask counsel, Mr. Bagatka.
Nothing further other than to thank you, the court reporter, Ms. Gonzalez, and the parties and the witnesses to the case. Mr. Hearing Examiner, thank you.
All right. I think we can all kind of join in that gratitude. Mr. Yar?
I join in that and nothing further, Your Honor.
Ms. Martinez?
Nothing further, Your Honor.
Mr. Elliott?
Nothing further, and I join in thanking everybody for being here.
This hearing is adjourned. I'm going to turn off the YouTube's feed, and I'm going to then turn off the Zoom. Thank you, Dr. Zazales, for being here. And thank you. And we're off the record, Ms. Gonzalez. Hey, off the record. Thank you again. I really appreciate it. You know, I appreciate everything you guys have done. And I think I said it last at the pre-hearing conference. We're still on the YouTube. What you've done by resolving this, from what I see, really is in the best interest of all the parties. I've never seen one more clearly in the best interest of all parties. And it obviously was arm's length bargaining. And it looks like some pretty tough bargaining to me and some pretty tough negotiations. So I really commend you all for doing that. Thank you very much. Any other comments?
Just want to say thank you to everybody in trying to get this done. I really do appreciate everybody's efforts very, very much. And that's on behalf of myself and on the corporation. Thank you.
All right. This hearing is adjourned. Thank you. Bye-bye.
Bye-bye now. Bye.
Bye, Ms. Gonzalez. Thank you very much.
I'm so sorry. And you know what? I have a note that I can give that goes something like, that's in the past tense, so you don't have to do the testimony again. So yeah. I don't know if you'd be interested in that. I don't mind, but I feel I could have done that. So I'll just let you know that.
I've done it the other way too, where you just ask the person the testimony that you previously did. Do you now swear under oath that it is true and to the best of it's?
Yeah.
Yeah, I've gone that through, but didn't come to me quickly. And there's another thing, and you know, it's nice to talk with you. This whole case might have been resolved easily if we did not have a pro se litigant.
Yeah.
Yeah, believe me. And I had to really treat her with kid gloves through the entire thing. And I did that for a lot of reasons. First of all, as a respect. And secondly, because there's a whole bunch of people standing behind her, if you will.
Yeah.
And that's important.
Yeah.
And I thought it might be more clear to them on the YouTube feed that I do it that way, basically repeat everything again, so there wouldn't be any question. And you might know one of my objectives in the way I conduct hearings is to prevent any possible basis for any alleged reversible error on appeal.
Yes, I understand. I work for judges, and they did treat not pro pers or pro se because they didn't understand procedure. So there was a lot more explaining of procedure and things like that. So
it's about the suspenders and the buttons and the belt and all that stuff at the same time. So thank you very much. You're just a total pleasure to work with.
Well, thank you very much. I appreciate that. I'm going to try to have this done for you guys by tomorrow. He had asked for it fast, so I'll get it done.
Thank you very much. Have a wonderful day and weekend too.
Thank you. Bye-bye now.
Bye.